Hello, and welcome to In the Privy Council, a podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honorable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week we are discussing the Caymanian case of Attorney General and Buray, citation for which is 2025 UKPC 22, Cayman Islands. This case concerns the compatibility of immigration legislation with human rights law, and the question of when courts ought to make a declaration of incompatibility. Let's start with a bit of Cayman constitutional law. The Cayman Islands Constitution Order, 2009, annexes a Bill of Rights, Freedoms, and Responsibilities, which lays out a number of rights broadly similar to the European Convention on Human Rights. Much like the British Human Rights Act 1998, the Caymanian Bill of Rights does not allow for directly striking down primary legislation as constitutionally repugnant on human rights grounds. Instead, under Section 23, if the court is in the proceedings minded to find that a provision of primary legislation is incompatible with the Bill of Rights, it issues a declaration to that effect, and the legislature is then tasked with what to do about such incompatibility. This case started because a number of people denied permanent residence in the Cayman Islands sued on the basis that the points system, which determines eligibility for permanent residence on a number of factors, including family connections, education, occupation, integration, and so on, was incompatible. Specifically, the claimants asserted that the provision of the Immigration Act, stating that permanent residence can only be granted if the applicant has 110 points, violated the provision of Section 9 of the Bill of Rights, which lays out the right to a private and family life, on similar terms to Article 8 of the European Convention on Human Rights. It's important to note, Section 9 has an exceptions clause, which states, so far as is relevant, nothing in any law or done under its authority shall be held to contravene this section to the extent that it is reasonably justifiable in a democratic society to regulate the right to enter or remain in the Cayman Islands. The claimant's argument was, in effect, that the exclusive consideration of the point system in granting permanent residency failed to be compatible with the requirement under Section 9 of respecting the right of private and family life, since considering only the point system did not ever explicitly give consideration to rights arguments. After losing at first instance in the Grand Court, the claimants went on to successfully challenge the point system before the Court of Appeal, where a per curiam judgment had a strange process of reasoning. First, in doing a proportionality analysis of the specific claimant's cases, the court found that the refusal of permanent residence was justified, and there was no particular human rights violation at all, let alone one that outweighed the public interest codified in the Bill of Rights that a functioning immigration system be permitted. Now, one might think this is the end of the case. No human rights violation. Court and lawyers grab an early lunch, we can all go home, it never makes it to the board. That, however, is not what happened. Instead, the Court of Appeal went on to find that although the point system would generally protect human rights, and of course, in this case, had not violated anyone's human rights, the legislature had failed to enact a comprehensive code to deal with the exceptional cases where it might violate human rights, purely hypothetically, and therefore, there was an obligation under the Bill of Rights to modify the entire legislative scheme of the points section to require an exceptional path for consideration of human rights in exceptional cases. Thus, a declaration of incompatibility was issued. As one might expect after this strange ruling, His Majesty's Attorney General of the Cayman Islands appealed to His Majesty in Council, which is where we pick up the case. For the board, my lord, Lord Legate, started by noting that it is, accepting extreme cases to be unlikely to occur in any realistic scenario, wholly inappropriate to make a declaration of incompatibility in hypothetical cases where no breach of rights has been found. There are three principal reasons for this. First, one method of controlling judicial review claims, which are already a drain on limited judicial resources, is that of standing. As the Baroness Hale of Richmond pointed out in The Crown on the Application of Chester and Secretary of State for Justice, 2014 Appeal Cases, page 271, at para 102, Supreme Court, allowing litigants to use human rights litigation to attack in hypothetical contexts, legislation that did not actually violate their own rights, would lead to a flood of unmeritorious claims, each with 1,000 hypothetical arguments that had no basis in reality. Second, an inherent restriction in the judicial function on the power and authority of the courts is, as Lord Legate writes, is that courts are not accorded authority to pontificate on any matter they please. Courts exist to resolve disputes between the parties before them. Even where matter are referred to the courts, by the way, such as in the United Kingdom under the rarely used Section 4 of the Judicial Committee of the Privy Council Act 1833, that is an exception very limited in application and still limits the courts to answering the question referred, not to generally pontificating. Courts are not there to pontificate, they are not the Pope. Now, this is not just a hypothetical argument of constitutional theory. His Lordship notes that when actually courts engage in hypothetical review, rather than dealing with the direct evidence presented to the court, they can make findings which turn out to be wrong or illusory because they are relying on potentially made-up facts, potential guesses. Court procedure, the way we have, however imperfect, of arriving at the truth via an adversarial judicial process, is not set up for deciding abstract questions no one brought to the case, especially on appeal when no new evidence is presented. Third, the purpose of the Declaration of Incompatibility under the British and Canadian and other similar hybrid rights instruments is to protect rights without upsetting the fundamental balance by which legislative sovereignty is invested entirely in the Crown in Parliament. Instead, the Declaration of Incompatibility is, as his Lordship writes, a remedy of last resort designed to bring Parliament's attention to the necessity to achieve justice for a claimant for whom no legal remedy is available. That means the claimant still loses the case, but there may be a chance for Parliament, should it so decide, to fix it. That is completely distinct from a general power to review any statute's legislative design when no rights violation is found, just a freestanding sort of blue pencil look over every word of every statute. Now, Lord Legate quotes the Lord Roger of Earlsferry in the case of the Crown on the Application of Rusbridger and Attorney General, 2004, 1 Appeal Cases, page 357, House of Lords, para 58. It is not the function of the courts to keep the statute book up to date. That important responsibility lies with Parliament and the executive. A declaration of incompatibility is a last resort remedy, not a reallocation of legislative power to the courts. If the courts could at random review and send back any legislation like an unwisely prepared meal at a restaurant just because they disliked the taste of it or thought it could be better cooked, that would in effect make courts the legislature, without which laws could not be passed. As such, the Court of Appeal is clearly wrong to review the entire law under a hypothetical case. The board also went on to add some strictly obiter dicta on errors in the reasoning of the Court of Appeal in its misguided declaration of incompatibility analysis. Namely, once the court embarked on this hypothetical frolic, they decided that the decision to refuse permanent residency automatically equated to a decision to be removed from the Cayman Islands. However, under the law, someone without an otherwise legal basis to remain can request that the Cabinet of the Cayman Islands declare an exemption to immigration laws in his particular case, since the cabinet has a duty, like all public officials, to follow the Bill of Rights in its actions. That is a statutory route to consideration of human rights outside the point scheme. The Court of Appeal was aware, of course, of this provision of the Immigration Act. However, it decided that it was inadequate because there was no specified procedure or detail. However, as the board pointed out, when considering the facial compatibility of legislation with the Bill of Rights, it is simply enough that there is a power allowing consideration of Section 9 rights. It is impossible to ask, hypothetically, if it will be exercised appropriately, and inappropriate to conclude in advance, it won't be on the basis of no evidence other than speculation. In other words, his lordship was clear that analyzing the exercise of the power requires, as one might have thought obvious, a case in which the exercise of a power has in fact happened. And for all these reasons, the board humbly advised His Majesty to allow the appeal. This case highlights some points of fundamental constitutional importance. First, even in systems of full judicial review of primary legislation on rights grounds, the job of the court is not legislative pre-review, or at least it isn't on paper. That is both a function of standing in common law countries, but more importantly, the fact that the only way to strike down a statute on the grounds that it could be better designed to avoid future hypothetical issues is for the court to essentially send back the statute and tell the legislature it should write better. The court is not a writing tutor. As Lord Leggett rightly notes in this case, there's a long line of authority, as well as legislative history, that provisions on declarations of incompatibility are themselves specifically designed not even to be codified judicial review of primary legislation. Quite the opposite. They are ways of ensuring there's a procedure by which the legislature can rapidly consider areas where a statute has failed to give someone a remedy the court thinks is needed. It is an extraordinary remedy of last resort, not a reason for the court to consider every word of a statute. Clearly, the Court of Appeal should have stopped once it was clear the human rights of the claimants had not been violated. However, the additional comments of the board, the Court of Appeal decided a statutory provision explicitly allowing consideration of human rights was too poorly drafted to count, highlights how even the analysis of the Court of Appeal was fundamentally flawed, even when we ignore the fact that they shouldn't have been doing the analysis at all. The judicial power is not there to determine if legislation is poorly drafted. To emphasize that point again, the courts are not statutory drafting writing tutors. The judicial power is there to resolve cases and issues before the courts. This is a particular egregious case of a court deciding it could act as a mini legislature. This is a phenomenon that has happened in many countries, whereby the judiciary aggrandizes its power beyond usually what's in the written constitution, such that it will strike down even provisions of the constitution itself. It is repugnant to the system of democratic government that both the United Kingdom and the Cayman Islands enjoy. It also has, as was briefly touched on, terrible policy implications in allowing any hypothetical argument to be made by a claimant trying to secure an outcome without any injury. It also makes it impossible to defend cases. How can someone defend against infinite hypothetical arguments? And leads to court deciding cases based not on evidence, but on speculative worries about future misuse, as the Court of Appeal did here, and as I personally argue the United Kingdom Supreme Court did in Miller 2, rather than the facts and the evidence. This may seem obvious, but apparently it wasn't to the Court of Appeal, so it's worth emphasizing. Courts decide cases on evidence and the law. Now, in the United Kingdom and countries using the Privy Council, there's been too steep a decline in the role of standing in judicial review. Cases like this are a reminder of why standing doctrine is important. That doesn't mean it needs to be as strict as the bogey that is the American standing doctrine, but it does mean there must be some meaningful way to focus the limited resources of the judiciary on the cases that actually matter, where someone has an injury and is in need of a remedy, which is why the judicial power is so important. Now, a point where I would disagree with the board, and indeed the United Kingdom Supreme Court authority it cites, is on leaving open the door for hypothetical declarations of incompatibility in unspecified, extreme circumstances. And I note this approach is not one even followed by the European Court of Human Rights, which has a fairly robust standing doctrine. If no one in a legal action can point to a flaw in the actual scheme of legislation, then I don't think there's any room for the declaration of incompatibility, no matter how extreme the hypothetical circumstances. And I think indeed, leaving something open because of extreme hypothetical circumstances is precisely the mistake the Court of Appeal made here. A declaration of incompatibility is a remedy. A remedy cannot be given in the abstract. Finally, the conclusions of the Court of Appeal show a worrying disregard for the actual text of the Constitution and the Bill of Rights, which, in accordance with the will of the people of the Cayman Islands, contains an exception to Section 9 for the purposes of immigration law that is reasonably justifiable in a democratic society, is say proportionate, regulates immigration. Now, any democratic society is justified in regulating immigration, but as a physically small place with a small population, limited resources, and a unique culture, the Cayman Islands is a particularly compelling and proportional reason for having strict rules on who may enter or leave. In this case, the legislation provided a number of reasonably justifiable factors grounded in logic, including family ties, which of course are connected to those fundamental rights in Section 9. And one of the most essential jobs of a court, particularly a constitutional court, is to start with the text of the Constitution from whence its authority derives. The balance of rights is set by the Constitution and the Bill of Rights in the first instance, not the courts to rewrite it. And any attempt to rebalance that, where the text is clear, is especially illegitimate. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style Blog. I've been your host, Elijah Granick. If you want more legal content, subscribe to the podcast on the platform of your choice, or visit our website, legalstyle.co.uk, or follow us on Twitter, @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and remember, God save the King.